Her spouse used the data in a divorce filing, exposing her affair.
Welcome to the Case Doctors.
She goes into the fridge to get a salami.
With John Simon and Alvin Wolff.
The fridge sends a note to the husband, your wife is banging someone who's not you.
The show where two of the greatest legal minds offer you advice on your cases.
Now that's a hell of a fridge.
The Case Doctors. We'll see you now.
Welcome to the Case Doctors. I'm your host, Christine Byers of Simon Law, and I'm joined by the Case Doctors, John Simon and Alvin Wolff. Now, between them, they have more than 80 years of experience as plaintiff's attorneys. So there really isn't a scenario they haven't already encountered in a case and figured out how to handle it. Now they're offering you the chance to tell them about the various problems or issues that are coming up in your cases and hear how they would handle it. But first, let's turn to some of the civil cases making headlines and hear what the Case Doctors have to say about them. This has to do with a Sam's Club slip and fall, and this is a case that was in the federal court and then it went back to the state court due to premature removal of notice. Because the August 2025 email correspondence did not put defendants on notice that the case was removable, their notice of removal was premature and therefore procedurally defective, a federal judge ruled. So he sent a slip and fall lawsuit back to the state court after ruling that Sam's Club jumped the gun in removing the case, concluding references to upcoming surgery did not equate to clear notice that the plaintiff's damages exceeded the $75,000 jurisdictional threshold.
Why wouldn't you want more than $75,000?
Yeah, I mean, I would. I'd rather be in federal court with an unlimited amount, than.
Oh, for sure.
Yeah, absolutely.
Actually, I had a trial once where it was removed to federal court. The lawyer had it remanded and filed a memo with the court saying that this case is worth not more than $74,999.99. Went back to state court. I tried the case for him, and I got a verdict in excess of $75,000. He got sued.
Really?
He got sued. It sounds to me like a waste of time. If your case is going to be worth more than 75, just stay there, or figure out a way to keep it in state court and sue the manager or whoever you need to sue to keep non-diversity.
Wow. Have you had experience with cases at the federal level going back down to the state level and like what?
Yeah, all the time. I mean, every case that most of the product cases end up in federal court because of, diversity issues. But it happens all the time. And like Alvin was saying, you need to think about who your defendants are. You need to think about where you want to file it. I mean, that's the biggest part of a big part of every case. Who do you want to be in front of? Do you want to be in federal court? Do you want to be in state court? What's the state court, jurisdiction, the county look like? I mean, all of those things go into it. It's not just get it and file it, but where can you file it? Now, if a case legitimately is worth $50,000 or $40,000, I don't think wherever you file it doesn't make any difference.
Yeah, why would you want to be doing that?
Right.
I mean, you just can't afford to do a case for that little anymore.
Gotcha.
And with Walmart, we say Walmart sells for less because they cut corners with customer safety. I just thought I'd throw that in there.
Thank you, gentlemen. Time now to turn to our email inbox for the cases our viewers have sent in for the Case Doctors to diagnose. Now, just so everyone knows, we're not going to reveal where these cases came from. We're not going to reveal any names or firms to protect the confidentiality of the cases. Instead, the Case Doctors are just going to focus on the issue in each of them. So as they say, the Case Doctors will see you now. So first up, my client's smart refrigerator logged late-night snack patterns and synced with a family app. Her spouse used the data in a divorce filing, exposing her affair. We're claiming the manufacturer failed to adequately disclose how behavioral data could be shared and misused, causing emotional distress and reputational harm. Do we lean more into invasion of privacy, Or is the emotional distress angle stronger with a jury? It's synced with a family app.
Couldn't you get that from the phone?
She goes into the fridge
Yeah.
to get a salami, and the fridge sends a note to the husband, your wife is banging someone who's not you. Is that what you're talking about?
That's a hell of a fridge.
Not exactly.
That is a hell of a fridge, man.
So it's more, it was showing patterns because he was trying to prove she was having an affair and that she was talking with her, with the her boyfriend.
So the husband didn't have access to the phone.
Correct.
But he probably had access to the fridge.
Correct.
And the fridge,
proved.
Called her out on it.
Yes.
The affair.
I don't get that.
A smart fridge is going to log every time someone goes in and out of it.
Why?
Because it doesn't want you to overeat.
Oh, okay. All right. Or have affairs.
Hey, the fridge doesn't want you to have any fun at all.
She's trying to tell her husband, what do you mean I'm not up all hours of the night talking on my phone to some other person that isn't you?
Said, the fridge told me you were, right?
But the fridge told him she was up having snacks at those times.
Well, that would be an invasion of privacy. And I think emotional distress goes hand in hand with invasion of privacy. So you got 2 for 1, really. You don't have to go for emotional distress and abandon invasion of privacy, because I think you have to go with the invasion of privacy to get to the emotional distress.
Problem solved.
Yeah.
Case doctors.
There you go. All right, here's our next letter. Dear Case Doctors, my client worked for a company that installed ergonomic smart chairs that track posture and time seated. The company later used the data to discipline employees for, quote, low productivity. We are claiming employees weren't properly informed of the scope of monitoring, and the data use exceeded consent, causing privacy violations and wrongful discipline. Are you bringing in tech experts early or waiting to see how the defense frames the data use?
Yeah, I mean, that sounds ridiculous, that they're going to discipline you based on how you're sitting in your chair and how often. And
it seems like an extension of, I know a lot of these firms will see if you're, on Facebook during the day, or you're on a porn channel during the day, or how you're using the company's computers. They track that data. And I guess, the defense for that would be I'm stretching my legs.
Are they chained to that chair and they can only do their job while they're in the chair sitting there?
Right.
Now, if it was an airline pilot or something, I would say maybe that's a little bit different. They got to be in the seat all the time.
Well, they have 2 pilots.
Or a bus driver, right? If he was out of his seat for 20 minutes out of every hour,
that would be concerning.
You'd question that,
especially if there was a log over the road.
So the question is, do you bring in tech experts early, or do you wait and see how the defense frames the data use?
I think you have to have someone initially to tell you that you have a case. So you probably can't avoid having somebody early on to look at it, right?
I'd want to see what HR's case was or what their information was before you brought in someone to take a look at it, because you're going to have access to the data.
Yeah, I think it's the case sounds like it's something that, it's bad conduct. I mean, I don't like it. I don't like what the employer's doing. I think most people wouldn't appreciate that. It seems unfair. It seems fundamentally unfair what they're doing. So I think, what would be the claim? Be a claim against the employer, right?
Right.
Would you need the chair for that?
Well, you need the data from the chair.
Just the data from the chair.
Mm-hmm.
Yeah.
All right. And another letter from our viewers. This one is titled The Indestructible Phone Case That Wasn't. Dear Case Doctors, my client's phone case was marketed as military grade indestructible, but it shattered on a routine drop, destroying the phone and critical work files. We're claiming deceptive marketing and breach of warranty, and it caused financial loss. Would you try this as a class action, or is it stronger as an individual economic loss case? And also, anyone have jurors get personally offended by marketing language like this?
First of all, I would criticize the client for not using the cloud. I mean, to have a phone and not have a backup is totally irresponsible.
True.
You know, everything they say is indestructible is destructible. I bought golf tees. They said these will last you for your whole life.
How'd that work out?
Well, the first time I broke one, I sent it back to the company, and they sent me a new package of tees, and they said, we'll do this once.
Because they keep breaking.
But I think, you know, their idea is you're going to lose this before you can break it.
Mm.
Yeah, and with the class action, you know, for that individual, whoever's handling that person's case, it's probably better for that person if they handle it individually. You know, the whole class thing sort of, I don't know, how often does it happen? Is it, you know, I guess if it's just broken, if it's just broken
Mm-hmm.
and they're not willing to replace it, then it's more conducive for a class because the damages are the same for everybody.
Mm-hmm.
But if you're making a claim that, you know, your information wasn't stored on the cloud or you lost, you know, there's some financial loss, that probably doesn't work as a class action because, you know, the damages are so different from each class member. You have to have enough similarity in what the damages are to make it work as a class.
Well, but let's say with the talc cases or Roundup, everybody gets cancer or whatever they get. It's a different degree of damages for each person, isn't it?
Yeah. Yeah.
Or would it be a mass tort or would it be a class action? And what's the difference?
Yeah, I don't know. I mean, how often does that, it would depend on how often it happens also.
Mm-hmm. Mm-hmm. Have you ever had cases involving products marketed as, you know, indestructible or foolproof, all the things? I know you brought up your golf tees, but have you had any experience, you know, with products claiming?
Not that are represented as indestructible, but I've had cases where components of a product have failed that never should have failed. You know, critical components, you know, part of a fuel system, for instance, in a car, or part of the braking system, you know, a crane, you know, with a backup device, you know, products where they have redundancies built in for safety that shouldn't fail. You know, those are things that, you know, we see that, but it's not a specific representation, you know, probably because it's a component part for the overall product.
Gotcha. Alvin, how about you? Any product cases where they were trying to sell them as, you know, indestructible or 100% guarantee, all those things?
You know, I just got a power washer that the commercial says, you know, you clean everything in 5 seconds. I can't even get it on the hose. Yeah, I can't even hook the thing up.
Well, it lasts a long time then if you don't.
Right,
if you're not
it's
using
going
it.
to last forever.
Right. It'll last you forever, no problem.
And have you ever had jurors get personally offended by marketing language that overstates a product?
Probably. Nothing comes to mind.
I've had jurors get mad with overstatements in medical records and medical billing that is not true. Jurors don't like lies. I think that offends them and makes them angry. But I've not had it in the products sector.
What do you think gets jurors riled up the most?
Not being honest.
Mm-hmm.
You know, trying to, you know, insulting their intelligence, I would say, gets them pissed off.
Mm.
You know,
invasive.
They get it. I mean, as a group of 12, I think a jury has a greater memory than any person that's ever lived. You know, they'll remember things, you know, collectively as a group. They're smarter than any person. They're better memory than any person. And you know, if you give them the information, they get to the right result most of the time, you know, in my experience.
Okay, gentlemen, that will do it for this episode of The Case Doctors. If you have a case that you would like the Case Doctors to dissect, send us an email at cases@thecasedoctors.com. And here's a QR code that'll take you directly to our contact page. Once again, we will be keeping all names and cases confidential. And thank you for joining us, and we will see you next time on The Case Doctors.